Everyone. We're recording this for posterity. Good morning, everyone. My name is My-Linh. I'm from Term Sheet Guru. I am also the managing partner of Metis Law. Let me just share my screen. Tony, can you allow me to share my screen, please? Actually, I can just reclaim it and share it. Great. So you've got the chat function there in the webinar. So if you want to jump on and chat at any time, feel free to do so. We will have a Q&A session at the end as well. But thank you for making the time out of your precious day today to learn about bad leaver clauses and tips on how to lose avoiding your company. A little bit about me. I am an entrepreneur and a lawyer. I've been advising startups for over 20 years. I've started and sold out of a tech startup myself, as well as a number of other companies. And I've been in the trenches of capital raising, both as a founder and as an advisor. And I'll tell you a little bit about why I choose to help startups. So about probably more than 10 years ago now, I was advising a range of startups as well as sort of medium and larger size companies, and decided to niche down and focus on startups for this one particular experience. I wasn't, my partner was a startup founder, is still a startup founder, and he was being advised by a mid-tier Australian law firm, someone that I'm sure you guys on the webinar today would have heard of. And I wasn't advising the firm, their company at the time, because, you know, partners, you sort of don't want to get mix business with pleasure. But I was watching him negotiate a cap raise with this mid-tier law firm helping him. And they were going back and forth about, 10 drafts of this agreement to raise capital. And I got so frustrated, and I said, look, I'm not going to act for you, but let me just negotiate this one provision and get the deal over the line for you. And I picked up the phone, spoke to the investor, and literally after, a 10-minute phone conversation, we closed the deal. And it made me realize that one thing that a lot of advisors don't realize is how difficult it is and how different it is to advise startups. And you really do, advisors need to step up and be more agile to get deals done for startups, because they can't afford to go back and forth, half a dozen times or a dozen times on deals the way that larger firms do. And ever since then, I've been focused on particularly startups, although I've been advising them for well over close to 20 years now. But the last decade or so, I've been focused specifically on helping startups and helping startups raise capital. On the screen, you'll see a few of the great startups that I've worked with in the past. The usual disclaimer, this of course is not legal or financial advice, it's general information only. Drop us a note if you do want legal advice, but that goes without saying. Our agenda today is to have a look at bad leaver clauses. Firstly, why do they matter? How to spot them in your investment agreements, what investors demand and what is actually fair, terms to be aware of so you don't get screwed, and of course, how we put this into action when you go away today. Before we get started, I'd like to get to know you a little bit better so I can customize today's talk for you. My colleague Tony is going to pop a couple of polls up for you to answer. And the first is, what is your role in your company or in the startup that you work with? Are you a founder, a non-founder, an advisor, or something else? That's the first question. And then the second question is, where are you at in your capital raising journey? Are you planning to do a cap raise? Are you in the process of raising capital? Are you advising on a cap raise? Or are you something else? So I'll give you about a minute to answer those questions. It'll just help me get an idea of who's in the audience today so I can tailor the talk to you. Okay, great. So we've got 67% of the audience today are founders and 33% are advisors. Fantastic. And 67% are in the process of raising capital and 33% are advising. So fantastic. So all the founders, 67% of the founders or 67% of the audience are in the process of raising capital. So this should be very, very helpful for you. And those who are advising, of course, would be very helpful for you to advise on for your startups that you're advising on as well. So thank you very much for that. That's very helpful. First is, why does it matter? Who cares about bad leaver or good leaver clauses? It matters because whether or not you are a bad leaver will determine what shares you get to keep or not keep when you leave your company. When you leave your company in circumstances that are considered bad leaver situations or circumstances that are good leaver, it's important. And I've seen it happen more times than I want to, where founders get pushed out of their company because of a bad leaver clause that they don't understand, and they end up leaving the company with nothing, and they end up losing their company. We don't want that to happen. We want a situation that's set up so that it's fair. And the question is then, what is fair? Before we start into bad leaver clauses, I want to give you some context on where this sits in your cap raise. And if any of you have been on one of our webinars before, you would have seen this. And this is our 3 pillars to raising capital successfully. So there are 3 main pillars. The first is your preparation before a cap raise. So before you even start thinking about raising capital, you build your network, you date your investors, you learn the lingo, you know, what does the bad leaver actually mean? And you build your data room. So you get your documents ready in your data room. The second stage we call sprout, which is pre-negotiation. This is where you think about your commercials. How much are you going to raise? Who are you going to raise from? What's the valuation? Then you structure your cap table. So how many people will be on your cap table? What's the makeup of founders versus shares that are issued to employees versus later investors? And then you create your term sheet, which is the document that sets out the basic commercials around which you're going to negotiate your cap table. And then the third pillar is grow. This is where you get your money in and you build your business. So in order to do that, you negotiate your investment contracts, you close the deal, you get the money. And of course, once you have the money, the exciting part is you build your business. So the section that deals with bad leaver clauses and understanding bad leaver clauses falls within that first pillar, which is learning the lingo. But it also flows through to your term sheet under pillar 2, creating your term sheet, and of course, negotiating your term sheets under pillar 3. So it's a very important part of the cap raising process. How do you spot a bad leaver clauses? It's not usually very difficult to spot a bad leaver clause because they're usually called bad leaver clause. The challenge is sometimes when they're not referred to as a bad leaver clause, you might see them being referred to as a capital L leaver provision. And the other issue is the interconnection between the bad leaver clause and other parts of your investment agreement, in particular, your vesting provisions. So what you'll typically see is the terminology. You'll pull out the terminology, good leaver, bad leaver, or leaver. And the provisions will usually sit either in your shareholders agreement, your founders agreement, or your subscription agreement. And there are 2 main ways that the bad leaver provisions can be dealt with. The first way is there is a definition in the contract of what a good leaver is. And it might look something like this. A good leaver is a founder who ceases to be employed or engaged by the company or the group of companies as a result of A, B, C, and D. And then you'll get a shopping list of scenarios that are considered to be good leaver scenarios. Some of these things might be if the founder suffers ill health, total or permanent disability, death, redundancy, or termination without cause. And then you'll see a second definition for bad leaver. And the bad leaver might mean a shopping list of items. So it could be a situation where the founder ceases to be employed or engaged as a result of fraud, serious misconduct, having committed a criminal offence or breach of a restrictive covenant, or if the employment is terminated for cause. The other way you might see bad leaver defined is a bad leaver is someone who is not a good leaver. So it's sort of a catch-all provision. And this catch-all approach is a little bit hazardous because it could leave you in circumstances where there are circumstances which you leave that aren't foreseeable. And because they don't fall within the definition of good leaver, they fall into the bucket of bad leaver. Everything else is a bad leaver. Then you could be caught out. So the preferred approach is for you to define upfront what a bad leaver is. So have that shopping list. So you'll see here, bad leaver means the catch-all, i.e. not a good leaver, or a shopping list of items. And it's much better to be clear upfront what that shopping list of items is. And we'll go into that in a little bit more detail in a minute. So terms to be aware of so you don't get screwed. We've seen some sketchy definitions of bad leaver. So the starting point is let's define bad leaver in a way that is clear and that is fair. And there is an accelerator out there, an Australian accelerator who everyone on this webinar, I'm sure, would have heard of, that defines a bad leaver to include a founder who is ill and no longer able to work, or a bad leaver or a founder who resigns from their position. And this is a little bit grey, right? Because if you're ill and no longer able to work, you haven't caused that. You haven't deliberately caused that. So is it really fair to treat you as a bad leaver? Secondly, if you resign, again, it depends on the circumstances. Not all situations of resigning ought to be treated as a bad leaver situation. So be careful about what that shopping list is of situations that are considered to be bad leaver. And we'll get to it in a minute, what's fair and what's not fair. The other sketchy one that we've seen is circumstances where the board can determine that you're a bad leaver. So if you get into a situation where you no longer control the board and the board can determine that you're a bad leaver, then again, you're in someone else's hands and you're at the discretion of somebody else. And that could get quite dangerous. So when you think about what circumstances should be considered bad leaver circumstances, really they should be circumstances that are genuinely bad. So fraud, committing an indictable offence, serious misconduct. They are things that you as a founder, assuming you're a founder, you as a founder deliberately do that would be considered to be bad. Once you've then established the scope of what's considered to be a bad leaver, what happens then if you are a bad leaver? Usually what happens is any shares that are vested gets bought back by the company. That's the usual way that these things are dealt with. The question then is, what's the valuation? At what price do your vested shares get bought back at? So you need to understand your vesting schedule and how many of your shares have vested at that particular point in time, and then the rate at which, or the valuation at which it gets bought back. And this varies quite a bit as well. We've seen situations where the shares get bought back at nominal value. So if you think about, if we go back to the scope of the bad leaver definition, if being a bad leaver is a situation where you've committed fraud, serious misconduct, or indictable criminal offence, then it's probably fair, to have your shares bought back at $1 because the risk to you is minimal. I'm assuming you're not going to do these things. So the risk of you committing it and having the shares bought back is minimal. Arguably, though, if you've already got a bad leaver clause and it's pretty broad and it covers things that aren't necessarily bad, and you've put a lot of effort into the company, you've created value, then another way to look at valuation, which is the rate at which your shares, your vested shares, get bought back, is they get bought back at a discount to market value. So you don't get full market value for it because you're a bad leaver, but there's a discount. And discounts can vary from anything from, we've seen a 20% discount through to an 80% discount. So it really is a commercial negotiation at that point in time. Things to be aware of is terms that lock you in. So, for example, that accelerator that I referred to earlier has a provision in that agreement which says if you resign at any point in time, then you're considered to be a bad leaver. So you could be with the company for 4 years. Say your vesting schedule goes for 4 years. You could be with the company for 4 years and you resign for personal reasons. Then under that scenario, your shares get bought back. All of your vested shares, because your vested shares would have vested over 4 years, they get bought back. And then the question is, what's the valuation at which it gets bought back? And so you don't want to be in a situation where you've worked for the company, created value for the company, you haven't been paid market rates because you're a startup, but you have to leave the business for personal reasons and you lose. You either lose all your shares or you get it bought back at a significant discount. So very worth being aware of what that buyback rate is. What do investors expect? Investors expect you to stick around, right? So if an investor is giving you money to build your business, they're expecting you as the founder to stick around. After all, it's you that they've invested in. But how long are you expected to stick around for and what's considered fair? So as I mentioned before, if you're in a situation where the company can terminate your employment and it's not a fair termination, then there are risks in there for you to lose your company. If you've been in the business for 3 years before you take on the investment and you haven't been paid, then is it fair for you to lose all of your shares if there's a bad leaver situation? So what's fair? Some things are pretty clear cut. Now, assuming we have a good scope, we've established a good scope for what constitutes bad leaver, and bad leaver is only those circumstances where you intentionally do something bad and the company can't illegally terminate your employment or your engagement, then it's pretty fair that if you leave as a bad leaver, you either get nominal value or a significant discount on your shares, because a bad leaver situation is one that you can control. If you've contributed a significant amount of value to the business, but you haven't been paid for a very long time. So if you've created IP, you've negotiated some really valuable contracts, but you've been paid a very small amount of money, then you should be able to get some value for the shares when you leave, perhaps a smaller discount. On the flip side, and this is a situation, if you're a founder and you have a co-founder, you need to think of this in terms of your co-founder as well. You don't want, or the investor doesn't want you to be able to up and leave at any point in time and take a large chunk of the company with you. So it is fair to have bad leaver provision, and it is fair to have a buyback. But you need to think about what have you contributed to date and what is the nature of the bad leaver situation. Have you been paid to date for the work that you've created or done for the business? Where it does get murky is when you start off with the definition of bad leaver that it's not truly bad. So you could have a situation where you have a definition of bad leaver that includes all those things that I listed before, fraud, committing indictable offence, a serious misconduct. But then you also have, as that accelerator that I mentioned has, a provision in the agreement that says you're a bad leaver if you leave within the first 2 years. Then what you could do is actually split up the valuation for the buyback. So if you leave under the bad circumstances, you might have a buyback at nominal value or at a significant discount. Whereas if you leave within X number of years, but you've contributed an immense amount of intellectual property up front and you haven't been paid to date on an employment contract, then perhaps the discount is a bit smaller. So you get some pay for your shares when you leave. Action steps for you when you go away today. What I'd like you to have a think about is have a look at your bad leaver clauses if you've negotiated them already or if you have them in your term sheet, and ask yourself firstly, what is the definition of a bad leaver? Is it a shopping list of things, or is it everything that doesn't fall within the definition of a good leaver? And if it's the latter, then is there a risk that there are things that will pop up that you haven't thought of? And is it possible then to flip the definition so that a bad leaver is a situation that is clearly defined to be situations that are actually bad? And then have a look at what are the consequences of being a bad leaver. What happens to your shares? Does it get bought back? If it gets bought back, at what rate, at what valuation does it get bought back at? Is it at nominal value? Is it at a discount? And then you need to take into consideration your contributions to date. If you've been working for sweat equity, then would it be fair for you to have those shares bought back at a value that is nominal, or should it be bought back at a discount to nominal value? Keeping in mind always that the scope of what a bad leaver is the most important part, right? If it's fraud, things that are within your control and which are truly bad, then it's arguable that it's fair to give up a larger discount on the buyback. And the rationale behind that is obviously because it's in your control. So you won't be committing those things anyway. So we run a masterclass on negotiating term sheets. We have a special offer for everyone who's on the call today. It's $14.99 full price, and you get an investor-ready term sheet that allows you to go out and negotiate the terms of your cap raise. If you sign up in the next 24 hours using the code BL, bad leaver, 799, you'll get that price you'll get the seminar for $799. It's a half-day seminar. We go through all the details on how to navigate your way around a term sheet. We do the negotiations with you. And like I said, you go away with a term sheet ready to negotiate. We'll send you those details at the end. You can connect with me at termsheet.guru. We have a Facebook group called Capital Raising Founders Australia and New Zealand, where we share lots of tips and tricks around negotiating term sheets. We have a great podcast called The Raise, where I talk to founders who have cap raised in the past. You can also find me on TikTok at My-Linh_lawyer. Before we finish up, I'll hand it over to you. Are there any questions? Let me just have a look. Any questions from the floor? Don't be shy. Okay, no questions. I've answered all your questions. Great, thank you. Well, you do have my contact details. If you have any questions, do feel free to reach out to me at one of those places on email, through the website, or through TikTok. Otherwise, thank you very much for spending your half hour with me this afternoon. There is a little survey that we will send to you right after you log out to ask you about what else you'd like to learn about. So please do answer that. Hope you enjoyed the presentation, and good luck with your capital raise.